rise?
My lord, if I could just take up your invitation just to make two more points. One in relation to something that Lord Justice Nugee said, and one second point in relation to what Lady Justice Falk said. With regard to the first one, so far as the general principles are concerned, Lord Justice Nugee was asking about effectively whether there should be a default implication that on a retirement agreement, the partner would be, the retiring partner would be paid out at full value or fair value, however one put it. And in relation to that, if I could just briefly take the court to 4 paragraphs in Drake and Harvey, which I handed up. This was one of the line of 3 cases in this court dealing with disputes about the construction of provisions for payment on retirement or death. And the judge in Drake and Harvey, the trial judge, one can see at on the head note, the last 4 lines above held. The judge held inter alia that where the partnership deed was silent as to the basis of valuation for the purposes of an account, the appropriate value was one that was fair, and there had to be clear reasons not to apply fair value. So that was the approach he took. And in relation to what this court
can we just go back for a moment to see what the scale of what the context for that issue was?
So
was this the interpretation of a partnership deed?
Yes, on the head note, my lord, point little f, 3 lines above that. Clause 19 of the deed dealt with the ascertainment of the amount to be paid on the death, bankruptcy, mental incapacity or retirement of a partner. Clause 19A provided for there to be 3 elements in the amount to be paid to the retiring partner, including relevantly.
Did this retirement come within clause 19?
Yes, so the dispute was what clause 19 meant.
All right, so it was a construction issue here.
Yes, the reason it assumed some importance as a case was because had been an issue as to whether effectively if you have an unclear provision, there was a default answer. So do you start with a default presumption that there will be a payment on fair value or full value? Or do you simply look at what has been agreed with no prior presumptions or default rules? And the trial judge had effectively taken the approach of assuming that you start with a presumption of fair value, unless that's ousted by the terms of the agreement.
What was the alternative to fair value?
Well, just by point F, the continues there, the partnership deed contained no express direction as to the basis on which capital assets should be included in such accounts. So the question is, do you put those in at book value, or do you put them in at
So the issue there was book value or fair value?
Yes.
So that's one that is at a later stage in the analysis than what we have here, which is any value.
Yes, indeed, my lord, but I say the same logically and as a matter of principle, the same thread should run through whether you're asking that question or the question which arises in this case, because in my submission there's no logical distinction between them. The approach of the court was to say, well, the circumstances of partnerships vary so much, and there are the different balancing exercises between interests of continuing partners and departing partners, or estates of deceased partners. So it's not right to start with a presumption or a default rule. What you have to look at is what people have actually agreed. And in Drake and Harvey and White and Ham, the question was really the approach to valuation. So it was clear from the agreements that there was to be a payment, but the question was, how do you assess that payment? Is it based on book value or actual value or something else? And
so we're being asked to read across things that were said in the context of issues about basis of valuation to the question of entitlement.
yes, because I say the same principle logically applies. So if you look at the reasoning for that, there's no difference in why the same reasoning would apply, because this court in those three cases has made it very clear, as set out in Lindley and Banks, that you don't approach it with any presumptions or default rules.
But there is a question as to what you're approaching.
What's the
What these cases are saying, on these cases saying, in construing the agreement, that's what you're doing.
Yes.
You should do that on the normal basis,
Yes.
rather than with some sort of fixed idea or starting point in mind. That is a different question, isn't it?
Well, my lady, there's in one sense there is a difference in that if you've got a detailed written agreement, you're construing that agreement and you're looking at what that agreement says. And obviously, if you've got an ad hoc agreement to retire, that might be in a detailed written agreement of the same kind, or it might be of a more informal kind, as in this case. But in each case, my lady, I say what is clearly the same is that you're looking at what they've agreed. And there may be elements of what they've agreed that you have to spend some time looking at to work out exactly what was agreed. But ultimately, you're looking at what they've agreed. And if they didn't agree things, they didn't agree things. But what is clear from those cases is that this court said it wouldn't be right to approach working out what people have agreed with any preconceptions as to whether a retiring partner or a deceased partner's estate should be paid out at full value, fair value, or alternatively book value, or something else, because the circumstances vary enormously, and what you're really interested in what they've agreed. And if one is going beyond then looking at what is expressly agreed towards implications, in my opinion, in my submission, exactly the same factors are there at play, because my Lord Justice Nugee was effectively positing the question as to whether what one answer is to say you have a default implication if someone retires or there's a death without a dissolution and there's no specific provision about payment, effectively a default implication that there will be payment out at fair value or full value.
In this case, the partnership was for the benefit, when it was set up, was for the benefit of the parents and all the children.
The partnership?
Yes. I mean, at the beginning, when one's thinking about what the purpose of this partnership was, it was a whole family partnership. And so, I mean, I think what may lie behind some of our questions is the fact that until the point of the retirement, the respondent, one of the children to the partnership, had as much of a right to the assets, liabilities of the partnership as her brothers. It wasn't that, I mean, it starts from that point. And that must be, on at least one view, I'm not saying it's the correct view, a starting point.
Yes, well, my lord, in my submission, there are two main questions, as it were. One is, as a matter of principle, do you approach the implication of terms with an assumption that there's a default implication of an entitlement to full value, regardless?
That wouldn't be a default implication. It would be what I understand to be a statement of the findings of the judge, that this was that it had been intended by the settler of the founder of the partnership, that it was for the benefit of himself, his wife, and his three children. And so it isn't that you're starting from a blank sheet of paper and deciding, you know, whose terms are we going to imply. You're starting with a position in which each of the, by that stage, 3 partners had their, I think by that stage, equal share of, no, not quite equal, but they had their share of the assets and liabilities. And you're considering questions of implication of terms against that background.
Well, my lord, wrapped up in that, there are two aspects. One is what the judge did and what his reasoning was,
Yeah.
and then secondly, what relevant factors might be present in this partnership with regards to implication. And in terms of what the judge did, in my submission, as I submitted earlier, the judge didn't approach implication by saying, as per the M&S case, business efficacy, so obvious as to go without saying. What he said is, oh, well, this point has been decided in Sobel and Boston. So I'm just going to apply what the judge did in Sobel and Boston across to this case. And I'm not entirely sure what the jurisprudential basis was, but I think it's probably some kind of implication, whether of a contract or of a term. That's what the judge did. The judge didn't look at all of the factors in this case and say, in the circumstances of their agreement to retire, which is common ground, this is what I think against that background, and in those circumstances, it's right to imply in this case. That's not the approach he took at all. He said it's clear from Sobel and Boston I'm going to do the same thing as the judge in that case. And I've made my submissions as to the particular circumstances of Sobel and Boston. But if one then looks at the facts of this case, I have to come back to my point of principle, but if there was to be any kind of implication in this case concerning whether or not there'd be payment, and if so, on what basis, my lord is obviously correct that the partners there were 4 partners at the time of retirement, and each of them had equal shares. So there's obviously one relevant starting factor, but it's very far from being the only relevant factor, because one saw, I took the court earlier to how father regarded the partnership when he was setting it up, because obviously it was in one sense a family partnership, but it also had a very significant weighting, which everyone recognised, towards the parents. And you have, as Lady Justice Falk observed earlier, you have the provisions of clause 14.3, the retirement provisions in the partnership deed. So if one is looking at what they previously agreed in relation to retirement provisions, that is a provision pointing towards capital assets at book value, not a revaluation as if you had a sale or a dissolution. That's also what happened when Mother retired by agreement
well,
in
I think
1997.
we're going back to matters that we've been through before, and I'm also conscious of Mr. Walker's time. So is there anything...
Well, my lord, I was just...
Could you want to take us to, you mentioned there were 4 paragraphs.
yes, well, I was sorry, I was
Right, well,
diverted by your question, my lord, but...
You were, but we need to keep an eye on the...
Yes.
Maybe you could just point us to the paragraph.
Yes, well, if I can... shall I just give you the paragraph references, my lady? So in particular, paragraphs 28, 29, 63 and 64. But I would invite the court to read effectively the whole of the judgments in Drake and Harvey and Ree White on this point, in the sense that they do illuminate the reason why I say it's not appropriate to have any default implication as a matter of principle in relation to the question that Justice Lord Nugee was posing. What you have to look at is what people have agreed, and if they haven't agreed that there is to be a payment, then unless there's something in the particular circumstances of the retirement or the death, it wouldn't be right to have a default position that you imply an entitlement of the retiring partner or the deceased estate to full value or fair value, because the same reasoning applies. It has potential to do great injustice in many circumstances if you have any kind of default starting point for implying or some other kind of default rules. And with regard to the Scottish case that my learned friend has referred to, Eaton and Miller, that refers back to various earlier Scottish cases, which were considered by, like again, I can give the paragraph references. Lord Justice Chadwick in paragraphs 53 to 65 of Re White, and then paragraph 35 of Drake and Harvey. And effectively, whatever the position might be understood to be in Scotland, in this court, those Scottish cases are understood as turning on effectively their own facts, the construction of the particular agreements in those cases. They're not, in England, regarded as establishing a default rule, and the reasoning is the same.
Yes.
So Lord, I won't trespass on your time any further.
Thank you very much. Thank you, Mr. Peters. Yes, Mr. Walker.
The substance of this appeal is really about whether, upon the claimant's resignation from the family partnership in 2010, she was entitled to her partnership share, including a quarter interest in this 1994 tenancy that we've been talking about, which was a valuable partnership asset, as the judge held, or she was not so entitled, but only liable on her negative capital account that we come to contend. And of course, the consequence of that is that her quarter share of assets accrued to her brothers, as they say. And as my lady Falk said, this really turns on, firstly, the partnership deed. And of course, if the partnership deed is then silent, one looks at the general position in law. I intend to refer to three background matters. Firstly, the partnership deed of 1980. Secondly, mother's retirement in 1997, because that's relied upon by Mr. Peters. And then thirdly, Susie's resignation in 2010, before addressing the law and the questions raised on the appeal. So the starting point really is the 1980 partnership deed, which is found in the first supplemental bundle at page 4. The partnership is stated to initially have comprised father, mother, and Philip and Susie. In 1987, the supplemental partnership deed, which is found behind tab 2, then added Jamie, and the shares of the partnership changed at that point, as the supplemental partnership deed tells us on page 12 of the first supplemental bundle, to mother and father each having a quarter share, and the siblings each having a 1/6 share, which adds up to the full 100%. Key provisions in the first partnership deed are found in clause 14, and that's the only provision for the departure of a partner within the partnership deed. One reads in paragraph 14.1 that the partnership would be dissolved if father and mother, or the survivor of them, served a 6-month dissolution notice, and that appears to be what is well recognised as a general dissolution of a partnership with a winding up thereafter. So that's the termination of the entirety of the partnership. Clause 14.2 then goes on to say that the partnership would be, and the word used is dissolved again, as regards the partner in question, so that he shall be deemed to have retired, but not otherwise. In other words, the partnership otherwise continues. In 3 fault scenarios and 1 no fault scenario. And one reads from Romans 1, 2, and 3 that the 3 fault scenarios are prejudicial conduct, willful or persistent breach, or bankruptcy. The no fault scenario is Romans 4, which is death. And in each of those cases, there would be what I'll describe for the moment as a technical dissolution, because it's a phrase that appears in so much of the case. With the business then being taken over or continued by the remaining partners. The distinction is that it's not a general dissolution and a winding up of the entirety of the partnership. But as my Lord, Lord Jackson said earlier, there is a change in the partnership. We used to have 4, and we would have
Well, there's
3.
probably, I mean, having a lot of time seems to have been spent on this issue. And I mean, it may very well be that it ought to be called something different than technical dissolution, because as a non-specialist in this area, that term means nothing to me. Whereas actually, what we're talking about is a revision of the partnership, isn't it, or the revision of the partnership members.
It is. It's a convenient vernacular, if anything.
What is?
Technical dissolution.
Well, if you speak Chancery, yes, but for ordinary people, it doesn't mean anything.
No,
I mean, and contains in the seeds of all sorts of other problems. I mean, essentially, what's happened is that one limb of the partnership has departed, and the partnership moves on its remaining limbs.
Yes.
So, I mean, it may be that we're able to come up with something that actually says what's going on. But is your submission really that it's not going to make any difference to our?
No, it doesn't make a jot of difference. No, it's semantics. It's nomenclature. It's just a convenient phrase that's been used across several jurisdictions. It's been used in England and Wales, in Scotland, in New Zealand, and in Australia. So all 4 common law jurisdictions are using the same phrase, technical dissolution, for want of a better phrase.
Not to take more time in it, but I'm not understanding what's technical about it.
That's the point that was perhaps made in the Procter case, which I've mentioned further on in my skeleton argument.
What's the point?
The point is that it is the winding up that is the dissolution is not technical. The dissolution is a dissolution, but it's the winding up that's technical, because there isn't actually a winding up. So that's the difference.
The key point is, I suppose, you would say that what carries on is in fact a different partnership. It's a partnership between B and C as opposed to being between A, B and C.
Precisely.
That is a different legal relationship.
It is. It's got to be.
Simple as that.
The obligations and responsibilities are different, inevitably between 4 parties and 3 parties.
Yes.
But I'll come back to it. But I hope I'll be able to skirt through it fairly fast, because I'm not so wedded to the idea that it's some kind of necessity in this appeal. What is crucial, though, is when one reads on through the Partnership Deed 1980, Clause 14.3 then prescribes the financial entitlement upon a partner's at-fault forced retirement under the Roman 1, 2, 3 limbs. But critically, it doesn't prescribe the entitlement of the partner on a no-fault retirement by death. It's entirely silent on that point. So plainly, there's a gap in the drafting, which I'll come back to later.
Can I ask you this? Clause 1 of 14.3 has a definition of what is to be received, saying in the remainder of this clause referred to as a partnership share.
Yes.
I couldn't actually find those words being subsequently used.
That may well be true. It's not something that I've word searched for on my electronic copy, but that may well be true. And of course, it does say in the remainder of this clause referred to as a partnership share, and a point that Lord Justice Reimer said in Ham and Ham was that where you have a particular definition like partnership share for the purposes of a clause, that's quite different from the generally understood phrase partnership share as defined by Lord Lindley. And we'll come to that in Lindley and Banks. But the crucial point that comes out of this, when it was argued at trial, the trial judge correctly held that Clause 14.3 only applies to a Clause 14.2 at-fault retirement. And my lord, my lady, I've given you the reference in paragraph 7 of my skeleton argument to take you to the judgment where he said that, at paragraph 229, which in the core bundle is at page 134. And indeed, the judge dealt with not just one argument, but a sequence of 4 arguments that were raised, 5 arguments that were raised in trial. perhaps the most crucial part of paragraph 229 is that the judge, having determined that 14.3 only applies to an at-fault retirement under forced retirement under 14.2 Romans 1 to 3, it was accepted by Mr. Peters at trial that that was true. That was the case. It only applies to a forced retirement. Well, my lady, I said I'd deal with the partnership deed first, and I think I've dealt sufficiently with that for the moment. The next matter I needed to deal with was mother's resignation or retirement in 1997, and I've used both of those words quite simply because the judge has used both of those words in his two judgments, the first judgment from 2019 and the second judgment from 2022, and I've given you the paragraph references in my skeleton argument. The nub of it, though, really is that all parties then considered that mother was no longer a partner, though it was accepted that hers was not a termination to which clause 14.1 or 2 of the partnership deed applied. So she wasn't given notice by mother and father together, nor was hers a forced retirement, nor was it a retirement by death. And so for those reasons, of course, clause 14.3, the entitlement clause, upon a 14.2 Roman 1, 2, 3 retirement applying, 14.3 didn't apply to mother at the time. And what the judge tells us in his judgment is, and I'll come back to this in a moment, is that the accounts for the relevant period show how mother's interest was dealt with at that time, but they don't tell us why mother's interest was dealt with in that way. In paragraph 10 of my skeleton argument, I've flagged up the three things that mother's, or four things that happened to mother's entitlement in the partnership. The first is that a quarter share was distributed to the three siblings so that their shares increased each from a 1/6 share to a 1/4 share, which is why we're now talking about a 1/4 share. But of course, that's not mentioned in clause 14.3 at all, an accruer of mother's interest. Secondly, mother received her 1997 profit share as a credit to her capital account. That does happen to coincide with clause 14.3 Roman 3. Thirdly, mother received a drawing from her capital account, and the balance of mother's capital account was transferred to a loan account, and that coincides with clause 14.3 Roman 1. But there was nothing to which clause 14.3 Roman 2 applies, which was, as my Lord Justice Reimer picked up, the current account, although the current account is mentioned in the judge's judgment as, I think, paragraph 220, down on the last line, or the last sentence. So just pulling the threads together, the defendants, the appellants, accept that mother's resignation or retirement wasn't a termination within clause 14.1 or 2 of the partnership deed, and so they necessarily must accept that 14.3 doesn't apply. That's in their skeleton argument of paragraph 17. Now, despite that concession, both at trial and in skeleton argument on this appeal, at trial they submitted that when mother resigned or retired, she received the same as she would have received under a clause 14.3 force out. And they then argued at trial that somehow the 1980 partnership deed had been varied in 1997 when mother left, so that clause 14.3 reflected firstly her full entitlement upon her resignation or retirement, but secondly and more significantly, it reflected the full legal entitlement of anyone else leaving by a voluntary resignation or retirement, including, of course, Susie voluntarily resigning in 2010. Now, the judge found that on the evidence that failed. He held that there was no agreement in 1997 to vary the 1980 partnership, and if one looks to paragraph 221 of judgment, we find there the judge dealing with that point, where he says Mr. Peters submitted that what mother received was the same as that provided for under clause 14.3, and that as regards mother, the parties conducted themselves and proceeded on the basis that that reflected mother's, and indeed in the case of any other partner, any other partner's legal entitlement. I reject the submission that I can be satisfied with the treatment of mother's retirement demonstrates that the parties had reached an agreement or consensus which had the effect of varying or adding to the 1980 partnership deed relevant provisions. Quite simply, I have evidence from the accounts about what happened when mother retired, but not why it happened. It's likely that mother simply accepted what father determined at the time. And he then refers to parts of witness statements, because for the 22 trial, the defendants had been required by directions back in 2021 to identify those parts of their very lengthy witness statements which they were going to rely on, and the statements came from the 2018 trial, which parts of those statements they were going to rely on in the 2022 trial. And none of those evidenced an agreement in 97 to vary the 1980 partnership deed. And so there was quite simply no evidence of the circumstances either of mother's 97 retirement, or secondly, the reaching of any agreed terms. So there was simply nothing to prove an agreement to vary in 1997, so that the same provisions would apply to all future retirements as to mother's just one-off retirement. There was also a pleading point in that this variation of the 1980 partnership deed was never pleaded. So really, it was never something that had to be raised. Now, there is some suggestion in my learned friend Scott's argument that the point is being raised again here, in that somehow what mother received in 1997 was in line with the clause 14.3, and therefore somehow that carries over to Susie. But their inability to prove the agreement at trial really is the end of the matter. I will take you in a moment to the five matters that were all advanced at trial. And your lordship, my lady, will see that all five were knocked on the head by the trial judge. That's the second bit of background, mother's resignation. Now turning to Susie's resignation in 2010. And we need to go back slightly in the timeline to 2006. Because in 2006, as you've already heard from what the learned friend has taken you through, there was a discussion between father and Susie about the parlous state of the finances of the partnership. And Susie asked what would happen if a partner wants out. And father replied that they would be entitled to their 1/3 of the value and to walk away. One finds that in the supplemental bundle, page 16. It's the start of Susie's handwritten note, which runs through. First, sorry, did I say it was the first supplemental bundle, which runs through to page 20, and in the handwriting in the manuscript, you see it down at the bottom of page 20, or alternatively, there is the typed version at page 21, which runs through to page 25. And you see it even more clearly there in the last 3 paragraphs. When Susie asked father, if one partner wants out, father says, entitled to take 1/3 of the value on the date and walk away. Now, it's not entirely clear where the figure 1/3 comes from, because, of course, a third wasn't the correct figure at that time. There were 4 partners. It may well have been that father was simply seeing his 3 children as each entitled to 1/3 of the inheritance, and that's why he was saying 1/3. But we are speculating.
We got to caution you in the same way about this, that you've got the judge's findings that father had conversations with each of the children, and so I'm no happier with being taken to
No.
snippets,
It's too easy to cherry pick, I accept, yes.
particularly as there's a finding that the conversations were not necessarily the same with each of the children.
Precisely, yes. As the judge said.
Yes.
My lords, my lady, in September of the following year, 2007, you've been taken to this already at page 27 of this bundle. Father writes to Susie, page 26. 27 is the relevant manuscript page, or 28 has everything on.
So is that in the other supplement?
It's the first, sorry, first supplemental bundle. There are numbered pages 25A to H to I, and then the numbering restarts at 26. That might be the problem.
26 September 07.
It's the 36th page of the bundle. That's the one, my lord. The typed transcript.
We looked at this earlier.
We did, yes, and I don't intend to take you a long way through it. The first of all paragraph, which you've already read, father suggesting the sensible alternative is to resign, following which, if you're then satisfied to sign the document, you can be reinstated at once. Susie then replied, over the page 29 is her manuscript letter, the transcript at page 31. And the part to flag is second paragraph, and we discussed the following second bullet for coordination of applicants in the partnership, and the paragraph number 2 below that, which is text that follows the flagged bullet point above with an X next to it. This was not possible without renegotiation of the security, as some of this secret below is in my personal name, not held by the partner. So that was the problem at the time, that she couldn't resign because of the security. But in any event, 3 years later, in 2010, and you've seen this page as well, and I apologise for taking you to it again, but it's, I'm trying to give you the potted background, which is the basis for my submissions. Page 53, and over to page 54, you see the transcript of Susie's letter, 8th of July 2010. Dan suggested that I resign from GW Procter and Partners. I think this makes sense. This letter is therefore to confirm my resignation from the partnership with immediate effect. My Lord Justice Jackson asked whether there was anything in between 2007 and 2010 mentioned in the judge's judgments which precipitated this letter and the reference to resignation, whether father had suggested a second time that she resign. I can't find anything.
I think it was my Lord Nugee who
Oh, I'm sorry.
was interested in that.
I couldn't find anything.
No.
And then a year later, you've already seen, my lords, my lady, that father then tried to persuade Susie to defer her resigning, and that's a few pages on at page 67 in the bundle, the manuscript, the transcript being at page 71. To which Susie then replied.
So what's this leading to? Sorry about this.
Attention please. Attention please. This is the Incident Control Officer. Attention please. Attention please. This is the Incident Control Officer. A report has been received of a suspected fire in the main building. This is being investigated by the security fire team. All fire evacuation and first aid officers to alert status. Please stand by for a further announcement and obey the instructions of your local evacuation officer. Attention please. Attention please. This is the Incident Control Officer. A report has been received of a suspected fire in the main building. This is being investigated by the security fire team. All fire evacuation and first aid officers to alert status. Please stand by for a further announcement and obey the instructions of your local evacuation officer.
My lord, should I continue for now?
Yes, you got interrupted twice at the same time.
It's my lucky day. I'm looking for a
But
hat trick.
no, my point was really that obviously we're familiar with
course.
with this run of material, and it just helps. Maybe if you tell us before you embark upon it, or if you finish now, what's the point that you're seeking to make about Susie's resignation?
Well, the point of it is that it shows that she unilaterally resigned. Eventually, it was accepted that her part in the partnership had terminated.
Yes.
But one sees from the context that no terms were agreed,
Yes.
and that one can characterise it in an almost identical way to much of the case law, which is on a technical dissolution where no terms are agreed. I mean, it may already be that the court has seen sufficient to know that there just isn't anything there. But of course,
Well, I think we could have said when we came into court this morning that no terms had been agreed. That's not so much pushing an open door. There isn't even a door to push on. We've got that.
Well, Lord, I'll try to be quick then.
No, it's not a question of speed. It's just that, I mean, obviously what we're concerned with is what the consequences of that are.
My Lord, yes. I'll land on that very shortly, I hope. So one has seen, we've seen that Susie unilaterally resigns, it appears, and father seems to think that she can do that because his correspondence says to George Knoll that Susie was entitled to do so, and nobody demurred from it at the time. And indeed, then it's recorded in the partnership memorandum that we can see at page 100 in the bundle, which as my learned friend's already taken you to, which appears to be dated sometime in late 2011, because there's reference to a meeting with the partnership. NatWest informed of this negotiation, resignation of the meeting with the partnership on Thursday, the 10th of November 2011. So that pins this memo to after that date. And it also pins, the memo is pinned to before the 5th of April, which is a date mentioned in the following paragraph, not yet arrived. So it was recorded at the top of that memo that Susie retired from the partnership with effect from the 8th of July 2010. And we've seen father's view on that. So the question then is, what did the judge make of that? And my lords, my lady, you've already read, I think, paragraphs 223 and 224 on page.
Attention please. Attention please. This is the Incident Control Officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing. Attention please. Attention please. This is the Incident Control Officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing.
My lords, my lady, I think I was referring you to the core bundle, page 134, and the top two paragraphs, addressing the question of what the judge had made of all of that. And at trial, he simply found that paragraph 223, fourth line, ultimately all the then partners agreed to Susie retiring from the partnership and ceasing to be a partner as from the 8th of July 2010. he goes on, in circumstances where suited retirement was ultimately agreed to, I don't need to consider whether the partnership was one at will or whether under the partnership agreement she otherwise had a right to retire, in other words, without agreement, though these were issues canvassed before me. My Lord, my Lady, I don't think I need to take it any further than that, simply that the judge found that there was an agreed retire. And thereafter, of course, there was a new partnership between father and the brothers, which continued until father's death in 2014, on the 8th of January. So one comes then to the first issue of the appeal, technical dissolution. And I hope that I can be very, very quick on this, because I'm conscious that it's not really a matter of substance on the appeal, it's a matter of nomenclature or semantics. My Lord, my Lady, I have identified in Lindley and Banks, paragraph 23 of my skeleton, the paragraph 307. In the authorities bundle, it's found at page 161.
Say again?
161. And one can perhaps start the prior page in 160. At paragraph 306, Lord Lindley stated the orthodox of legal view as follows: the law ignoring the firm looks to the partners composing it. Any change amongst them destroys the identity of the firm. So over the page, at paragraph 307, the following helpful statement of principle was made by Chief Justice Eichelbaum in the Hadley case, which is a New Zealand law report case. I think I've got a typo in my skeleton argument, so he there says, in the citation in Lindley, in law, the retirement of a partner or the admission of a new partner constitutes the dissolution of the old partnership and the formation of a new partnership. And that's the simple point, that the claimant's retirement dissolved the 2010 partnership. And if one looks into the footnotes or one looks to the cases, we can find that same principle applied in the four common law jurisdictions that I've mentioned: England, Wales, Scotland, Australia, and New Zealand. So, clause 14.2 of the 1980 partnership deed is quite a useful cross-check, because even there, it's anticipated that the partnership would be dissolved upon the forced retirement of an individual, one of the partners, in an at-fault case, or indeed in the no-fault case of death. But as a matter of contract, Lindley continues at paragraph 309, which is at page 162 in the authorities bundle, to say this: it's of course open to the partners to agree as between themselves that a change in the firm will not affect the continuation of their partnership. But this only has effect as a matter of contract and doesn't alter the legal analysis set out above, which we've just been looking at. And indeed, back in the partnership deed, paragraph clause 3, that appears to attempt the same effect, albeit only in respect of death. Clause 3 reads, subject to the provisions for dissolution hereafter contained, the partnership shall continue until determined pursuant to the provisions hereof, notwithstanding the death of any individual partner. So that seems merely to reflect what Lindley has to say in paragraph 309. So then we come to this, the semantic distinction, because it seems that the law recognises two types of dissolution: a technical and a general. The latter, of course, is followed by a winding up and the end of the partnership in its entirety. And reading from Lindley, paragraph 24, subparagraph 1, that's found at page 241 in the authorities bundle. My Lord, my Lady, I have exerted that into my skeleton argument. I wonder whether it would be simply easier to invite you to read that, paragraph 28, rather than my reading it out loud, unless you wish me to.
No, thank you. We'll do that.
It distinguishes between technical and general dissolution.
Yes. It's really a transition, isn't it?
Yeah.
I mean, if it said it was a transitional dissolution, I completely understand what's going on, because in those circumstances, the legal entity has changed, but the business carries on.
Yeah.
Sorry.
The distinction is found in the three cases that are cited in Lindley, paragraph 2405. In the authorities bundle, that's page 242. And the three cases cited there are HLB Kidsons and Lloyd's Underwriters, Boyle and Bird, and Rochoda Party Limited against Commissioner of State Revenue. The last of which is an Australian case. And indeed, in Procter and Harling, which is a case my learned friend mentioned earlier, Lord Justice Longmore there recognised the phrase of technical dissolution. You can find that in the authorities bundle at page 62, within the judgment down at paragraph 23. 3 lines up from the bottom. He's referring to the paragraph in Lindley and Banks, 19th edition. So it says it's true that Lindley and Banks on partnership, 2402, calls a change in the composition of partnership a technical dissolution. The editor adds that it's usually the result of an agreement. And I mentioned earlier that there was an astute point made in the Rochoda case about a technical dissolution. The dissolution is real. It's not technical or notional, but it's the winding up which is notional, was the point made in the Rochoda case. And that's mentioned in cited in paragraph 2405. So the conclusion on that point is that the judge rightly described at paragraph 225 Susie's having left the partnership by way of resignation as affecting a technical dissolution, and he cited Lindley and the HLB Kidson's case straight from Lindley. So the next issue that I come to is the claimant's entitlement to the quarter share in the partnership assets, which is of course the nub issue in the appeal. Immediately after the two paragraphs down from where I've just cited in the judgment, the judge flagged the key question, paragraph 227. The key question is what, if any, recompense she was entitled to from the continuing partners or liability she was under to the continuing partners. And he then, over the next 5 or 6 paragraphs, from 229 through to 233, rejected 5 arguments that were raised by the defendants at trial. The first argument was already dealt with. At paragraph 229, the defendants argued at trial that Susie's entitlement, as governed by clause 14.3 of the 1980
To save us writing, I think you very helpfully put these in your skeleton argument at paragraphs 34 through to 38, haven't you? Which I think
My Lord, yes,
you're tracking at the moment, aren't you?
I am, yes, I'm just following my skeleton.
So we have there all the references and the facts about them on that.
My Lord, if it suffices, then I can simply say there was the clause 14.3 point which was rejected.
I'm sorry, I didn't hear that.
The clause 14.3 point which was rejected.
Yes.
The implied term point which was rejected. The variation upon the mother's resignation or retirement back in 97. That was the third point. The fourth point is paragraph 232, which is some sort of treatment by Susie or the brothers of Susie's position upon her resignation, somehow limiting Susie's entitlement, which the judge also rejected. And it wasn't pursued in oral submissions, 232 last line. And then finally there was an estoppel point based again on the same agreement that was asserted for when Mother resigned or retired back in 1987. That's paragraph 233. So the judge then poses the key question, having disposed of the possibility of there being an agreement in 5 different ways. He asks the question at 234, and my judgment question is, what is a matter of general law? The retiring partner will be entitled to honour retirement in circumstances where the partnership is not subject to the full winding up on such retirement, but the non-retiring partners continue in partnership and effectively take over the partnership assets, liabilities and the business. And he might have added, and there is no agreement as
Sorry,
to...
some background noise. I'm finding it a little hard to hear you.
My apologies, I have a habit of dropping my
No, it's
voice.
all right. It's when one reads off screen. But yes, carry on.
Paragraph 234, the judge poses the question to be answered. And he may have added where there is no express agreement as to financial terms. And he then goes on to start with mentioning the Partnership Act, whilst, of course, he just recognised that this was a technical dissolution, not a general dissolution with winding up. And, of course, the Partnership Act only applies to a general dissolution with winding up. But it would be unfair to criticise him for taking that comprehensive approach, because that's exactly the approach that was taken by Lord Justice Lewison in the Ham and Ham case, where Lord Justice Lewison recognised that in that case, sections 39 to 44 of the Partnership Act didn't apply. But he nevertheless started from that position.
So it's the run-up.
It is, it's the run-up, but it has no effect on the outcome. And you see that in the authority fund at page 38. Paragraph 22, Lord Justice Lewison said, sections 39 and 44, of course, deal with the position on the winding up of the firm, which is not our case. That's precisely
Page
page 38,
paragraph 21.
paragraph 22,
22. Yes.
first 2 lines.
You accept that section 39 doesn't apply in this case?
Yeah.
Yes.
Later on within the judge's judgment, paragraph 246, he identified that a retiring partner's entitlement would depend on the interpretation of the partnership agreement, and he cited Ham. And of course that's correct, because that's exactly what Lord Justice Lewison said in Ham at paragraph 5. John's entitlement is a contractual entitlement, what it is, therefore depends on the correct interpretation of the partnership deed. So that's really the starting point. And Lord Justice Briggs, as he was in paragraph 41, makes the same point. Lord Justice Lewison then in Ham, before addressing the express agreement to be construed, he carefully distinguished between 3 things: the partnership's capital, the partnership's assets, and a partnership and a partner's share. And in paragraph 15, he says that the capital is the aggregate of sums contributed by the partners, which is uncontroversial. But he goes on to distinguish that and say it's not the same as partnership property. And he cites Lindley in its 19th edition, paragraph 1701. By the capital of a partnership is meant to be the aggregate of the sums contributed by its members for the purpose of commencing or carrying on the partnership business, and intended to be risked by them in the business. The capital of the partnership is not, therefore, the same as property. The capital is a fixed sum by the agreement of the partners, whilst the actual assets of the firm vary from day to day. So the distinction is now made between capital and property, the capital and assets. And he goes on to cite the next paragraph from paragraph 1702, that's his paragraph 16. Lindley and Banks go on to say in the next paragraph, as Lord Lindley pointed out, there's a fundamental distinction between a firm's capital on the one hand and its assets, sometimes confusingly called its capital assets on the other. That distinction is critical to an understanding of the true nature of the capital, and is, moreover, frequently overlooked by the partners and their advisors. And in Ham, that distinction has been overlooked in clause 3.1a of the partnership agreement, which is cited down at, or mentioned down at paragraph 26 of Lord Justice Lewison's judgment, where he says the first point to make about the partnership deed is that it doesn't follow the distinction made in Lindley and Banks between capital and assets. Like others before them, the drafters of the deed overlooked the distinction. Clause 3.1a envisages the capital of the partnership will consist of assets, and that the assets will be credited to each partner. And we similarly have, in my submission, that same lack of distinction in the 1980 partnership deed, at page 5 of the first supplemental bundle, clause 5. The third matter, which Lord Justice Lewison then distinguishes, is paragraph 20 of his judgment, the authorities bundle, page 38. So far as a partner's share is concerned, Mr. Partridge again relied on Lord Lindley's definition quoted in Lindley and Banks, paragraph 1905. What is meant by the share of a partner is the proportion of the partnership assets after they've been realised and converted into money, and all the debts and liabilities have been discharged. And that's the crucial definition, really, because it is talking about converting into money, realising, and the necessary implication of that must be that one realises in the open market and the debts and liabilities are paid off, in which case one already has advance warning of the basis for valuation. In Ham at paragraph 22 and 23, I've already referred to paragraph 22, where sections 39 and 44 are flagged up. Lord Justice Lewison then continues, thus it is that Lindley and Banks go on to say at paragraph 1906 that it's considered that Lord Lindley's definition is as such incomplete, and that a full understanding of the nature of a share is only possible if that entitlement is analysed at 3 stages of the firm, namely, 1, whilst the partnership's continuing, 2, on a general dissolution, and 3, on the death, retirement, or expulsion of a partner. And perhaps Lord Justice Lewison's carefully avoiding the phrase technical dissolution, but of course the third option is, as we've just been looking at, what is often described as a technical dissolution. And then one reads paragraph 23. He deals firstly with the second stage, and then halfway down the paragraph he deals with the third stage. He says, as regards the third stage, they observe that where it's expressly or impliedly agreed that the partnership will continue, notwithstanding the change of the precise nature and value two distinct matters of the deceased or outgoing's partner's share will depend on the terms of the partnership agreement, paragraph 1910. And then at paragraph 23, Lord Justice Lewison cites Lindley, paragraph 1910 there, for the proposition, which I've taken directly from the textbook and put into my skeleton argument at paragraph 43.3. And this first deals with where there is an express agreement. And Lindley says, if any of the above events cause a general dissolution, the position will be as described in the preceding paragraph. Where, however, it's expressly or impliedly agreed that the partnership will continue, notwithstanding the change in the firm, the precise nature and value of the deceased or outgoing partner share will depend on the terms of the partnership agreement. So that's the starting point. But then Lindley continues with the next paragraph saying, if, as will usually be the case, the agreement establishes the manner in which the deceased or outgoing partner's financial entitlement to respective share is to be ascertained and paid, and provides for the devolution of legal title to any partnership assets which may be vested in him, his share may be properly regarded as a pure debt with effect from the date on which he ceased to be a partner. The key phrase is the next one. It's only where such terms are omitted that difficulties may arise. Now, of course, in the Ham case, clause 4.2 of the partnership agreement was determinative. It sufficiently answered all the questions. One sees it in the case at the top of page 35 in the Authorities Bible, where it's been set out by Lord Justice Lewison. By clause 4.2, the partners who are receiving a dissolution notice had the right to have the partnership wound up under the Partnership Act 1890, or to purchase the share of the other partner or partners at the net value of such share. So the latter option was a technical dissolution, a buyout. And clause 4.2, those words I've just cited were then interpreted. And the questions in Ham then became, firstly, what in clause 4.2 was meant by the word share? And secondly, what was meant by value or net value? So it was a matter of interpreting the partnership agreement, interpreting the contract in Ham. It may assist the court to note in paragraph 5 that Lord Justice Lewison said in lines 3, 4 to 5, there are no presumption or default rules which point towards one basis of evaluation of an outgoing partner's share rather than another. And he cited there the case of Ree White and the case of Drake and Harvey, which my learned friend relies on. And that's absolutely right. The key point is that there's no presumption of default for a basis of valuation. What it doesn't address is the prior question, and that's the entitlement to a share. To the extent that my learned friend says, well, there's no default rule or presumption as to entitlement to a share, that is not what Ree White, nor Drake and Harvey, nor Ham say. They're not addressing the point at all. The entitlement to a share is an entirely different matter. And I don't, unless, Lords, my lady, you wish me to take you to the relevant paragraphs in Drake and Harvey, I don't intend to take you through Drake and Harvey. I can simply give the paragraph numbers.
Yes.
25, 29, 30, 39, 63 and 64.
As demonstrating what?
And they simply show that that case, and indeed Ree White, are only addressing the question of whether or not there is a default rule as to the basis of valuation, not the prior question of the entitlement to a share. It's the basis of valuation of the share, not the entitlement to the share. And of course, as my lady, Lady Falk, said, that is a matter also of just interpreting a contract. It's not a matter that we're dealing with here, because we don't have a contract to interpret. There's an absence of any provisions in the partnership deed as to entitlement upon a no-fault retirement by agreement. And so, just clearing up, or sweeping up the various points. Unlike Ham, our 1980 partnership deed doesn't have a clause that addresses entitlement upon resignation or retirement, and indeed that was accepted by my learned friend and recorded in the judgment at paragraph 229 at the end, 229, and there was no ad hoc agreement. Unlike the case of Bottrell and Harling. So the judge in our case held there was no ad hoc agreement over the page of Court Language 5 and paragraph 231, 232, if necessary 233 on the stopping point. The defendants, the appellants say that Susie agreed to, or they asked Susie to repay her negative capital balance. But of course, we can see from the correspondence that she disputed her liability to do so, to pay that. And it was only eventually conceded very late in the day. And you see that at page 103 of First Supplemental Bundle. But it was
Why do you mention that she disputed it? I mean, I appreciate she did, but why is that of assistance to you?
Because it shows that there was no agreement as to the terms of her leaving the partnership. It shows that they were still in dispute over what.
Would equally show that she just wanted to leave the partnership on a drop hands basis.
She certainly
or
wanted
that she
out.
just didn't want to pay any money.
She certainly wanted out, and she didn't want to pay any money.
I don't understand why it assists your argument.
Well, my lord, it might be that I can simply stop by saying there simply wasn't an agreement. The point was made by my learned friend that Susie didn't seek any payment from them after she resigned or retired. And that's a point that's made by my learned friend in his skeleton on several occasions. And indeed that she didn't look outside the partnership accounts. But of course, there's a very sound answer to that, in that back in 2010, the existence of this very valuable HHJ tenancy was just not conceived by anybody, it's fair to say. At the 2018 trial, there was correspondence, family correspondence, that ran to, I think it's about 1,500 pages, and there was a single mention of a tenancy agreement in all of that correspondence. Indeed, the very first time it was raised, and I think this is common ground, the very first time it was raised as between the parties was in the defendant's defence, which was dated either 2017 or 2018. And you find that in the second supplemental bundle at
Page?
110. And also 137. 110, paragraph 8, Roman 2. 1975 trust.
Just hold on a second.
Sorry, are you giving us electronic numbers? Or, no, page numbers, is it?
In Adobe Pro, if one types in 110 into the electronic supplemental bundle 2,
Thank you.
then it should jump straight to the page. It is the 6th page in the bundle.
Yes, paragraph.
paragraph 8, Roman 2. And it's mentioned again within the same pleading, a page of that bundle, page 137.
Right, so it is the sentence at the top of Roman 2, the first sentence, that was the topic for the first appeal.
The existence or otherwise of the tenancy, yes.
Right, so they said it exists, you said it didn't exist, and they were right.
And they were found right, yes.
And so your point is that back in 2010, that the existence of that tenancy was not suspected.
No.
And so what we're arguing here is about the division or otherwise of a windfall.
Of a tenancy that was just never conceived to exist.
Yes.
And indeed
But so far as the parties were concerned, money that they didn't know they had, if indeed it's shared.
Not quite, no, because
How does it work?
Because the land is held by family trusts.
Yes.
To the extent that there is no tenancy agreement, the land can be distributed between the three siblings. But to the extent that there's an HHJ tenancy, which is held solely for the benefit of the brothers, it sterilises the land, and the brothers hold all the purse strings.
So it can't be distributed.
No, not unless it comes out from the farming accounts. And indeed, I don't know whether it's apparent from the judgments, but since the death of Susie's parents, she's not seen a penny, because it's all been sterilised by these arguments, by the AHA argument. And the brothers have been living on the land ever since. And indeed, just to drive the point home, it's found in the first judgment. If I can take you to the second supplemental bundle, page 361.
Paragraph?
The first judgment from 2019, paragraph 222.
Yes.
You'll see that the judge rejected the defendant's assertion that Susie knew about the 1994 tenancy. And you'll see that he describes it as a comparatively... she only knew about it comparatively recently, and talks about Philip's general mental gymnastics. Initially arguing there was an oral tenancy, and then that changed at trial to a tenancy by conduct. And down on page 366, last paragraph, which is 250. You see the judge saying there, the last two lines, Philip may not have understood what the legal effect of the arrangement was until he was advised after father's death. And indeed that was apparent from the trial, because opinions were disclosed from Mr. Peter Williams, in which he said, well, in the accounts, money's moving around, although money never changed hands.
Could you give the paragraph reference again, please?
I'm sorry, 366, paragraph 250 at the end. Is that the one?
The three-line paragraph?
It is, yes.
Yes, okay.
Last two lines. You have all of those paragraph references.
Yes. Thank you.
So in reality, back in 2010, there simply couldn't have been an agreement about the HHJ tenancy because it wasn't conceived to have existed, even by the brothers. It was a 2014 argument that was only ever raised with Susie in a pleading in 2017, 2018. And the effect of that was that the family trusts couldn't get at the family assets or the family inheritance, which has meant that there's been no distribution to Susie at all from her parents' estates. Well, I just dealt with the absence of any agreement, and the consequence of that is that the judge moved on from looking at sections 39 to 44 of the Partnership Act, and at paragraph 238, he cites Lindley paragraph 1911, which deals with the entitlement on retirement where there's no contrary agreement. So absent agreement, what's the position? And,
Right, so this is where the run-up ends. We reach the wicket finally.
with yeah, my apologies
Yes.
for the long run-up from the
No,
boundary.
no, but paragraph 238.
Yes.
Yes.
So, in the absence of any express provision in the partnership agreement or an ad hoc agreement between the partners, the entitlement of the deceased or outgoing partner in respect of his share will, in the norm, and it does identify immediately that that partner has a share, will in the normal way be strictly be represented by his proportionate share in the net proceeds remaining after all the partnership assets have been sold and the partnership debts and liabilities paid and discharged. However, where there's an implied recognition on the part of the outgoing partner that the other partners will continue the business, those other partners will be treated as entitled to acquire his share at a valuation, and the court will direct the necessary accounts and inquiries for that purpose. And precisely the same propositions made in Blackhead, Ord and Harrow, paragraph 1834. If a partner has left the firm, but the firm continues without winding up, the implication is that he's retired and that there'll be no sale of the partnership assets, but he'll be paid out at a valuation. And that's exactly what the judge did in this case. And he relied for that principle on Sir Ballon Boston, which was the decision of Mr. Justice Goff, who was appointed to this court the following year after that decision. And it is apparent to note that in the 50 years since Sir Ballon Boston was decided, it's never been considered wrong in any textbook or any authority that I've come across.
Has it been considered at all?
Well, that's perhaps a point that I don't know the answer to. There's nothing in the footnote.
We've not been referred to any authorities in which anybody's followed it or distinguished it or commented on it.
No, and to that extent, it may be vulnerable.
What you can say, as this shows, is that the leading textbooks just have assumed it's right. They haven't queried its reasoning.
Yes, and if anybody's read those textbooks with a similar set of facts, they haven't thought to say, no, that's plainly wrong. Somebody who has a quarter share, for example, in a partnership the day before resignation, forfeits that share the day after or the day of resignation, even absent any terms agreed. It's a last man standing argument, because by the defendant's argument, of course, the two brothers now are looking at one another in the eye and seeing who will last longest. Because if one of them dies, then the other one scoops the pool on their argument. Or if one of them retires without terms, then the one still standing scoops the pool, absent any terms. Because that's the consequence that they argue, which seems just so inherently unlikely and unfair, to use Lord Justice Rymer's words from the Ham and Ham case.
I'm not in a position to know, but in the various textbooks we have, just doing a search on Sobel, it does come up as footnoted in a number of places. So it is your point. Can you make the point that it hasn't been doubted by the textbooks, at least?
Exactly, yes.
Query whether we can find any citation.
That's fair, yes.
I mean, I'm looking, for example, just pages 146. It's mentioned twice in the authorities bundle. I appreciate it stood for more than one point, and it's mentioned a couple of times. It's mentioned on page 147, mentioned on page 151. And inconveniently, there's another case involving a Mr. Sobel, mentioned again at 146. Or are we back to where we started? Yes.
I think we are, yes, that's where we were before. Your search had obviously gone full circle.
Yes. Actually, it comes up 171.
It's twice on 146, I think. Top paragraph and middle paragraph. Maybe 147 is a different case because that's 20-something years later.
171 is back to it, footnote 630. Where Procter and Procter
Yes.
is equally footnoted.
Yes, I'm not sure I can rely on that just in this call. Might be nice, but
172, 173, etc., etc.
did you have 149 as well? Down at the bottom, it's not footnoted there.
Right.
But it's footnoted over the page. Twice over the page. 171, I think you found. 172. 173.
Right. Well, I'm finding that there are quite a number of much later references to Sobel and Boston. Your point is it's not been doubted.
No, it's not been doubted, and if anything, it's simply been cited for the points that it's
Cited, not doubted.
No, exactly, for the points that it appears to be authoritative. It's worth flagging that the way that the case was dealt with by Mr. Justice Goff, it's already been explained to you that there was the retirement of one of the partners left from a four-partner firm, it appears, and he wanted the declaration that the partnership was dissolved and a winding up. So he was after a general dissolution with winding up, and what the judge found was that there wasn't a general dissolution, but there was an agreement for a technical dissolution. So although the phrase general dissolution and the phrase technical dissolution don't appear in the judgment, that's essentially what he is finding. So my skeleton argument, Article 1.2, identifies this, that Mr. Justice Goff could only make a prima facie finding of fact, he says at page 1589D, and he found against a, quote, dissolution, by which I would submit that meant a general dissolution, because he found prima facie the parties agreed that the plaintiff should retire, which is, of course, a technical dissolution. So his reasoning is found to be threefold, including, amongst those three reasons, that there was a letter and an advert, both of which referred to the defendants continuing the business. And it appears that that was probably a common advert. There was a notice published in the Law Society Gazette in the Authorities Bundle, page 16, and next to letter G, you see the advert that was put, the notice that was put in the Gazette. Third line down, the partnership was dissolved by mutual consent, and from that date, the other three continue to practice at the same address under the same firm name. So plainly, the word dissolution wasn't being used in the sense of general dissolution. It was a technical dissolution. But then Mr. Justice Goff addressed the effect of that retirement or technical dissolution in the context where no financial terms had been agreed. And that wasn't a prima facie finding, that was just a finding of the consequence if, on the prima facie finding of a technical dissolution, there was a technical dissolution. And so over the page, at page 1591, Lindley on partnership is cited, and it's the 1971 edition, and is helpfully provided at tab, I think it's 9C. And he has flagged the relevant passage in the authorities bundle at page 263, which is the same passage as is cited by Mr. Justice Goff in so that. And the partner retires, the firm is thereby dissolved, so far as concerns that partner. And if, on the provision for such retirement, either originally or by subsequent variation, the partnership agreement is silent as to how the retiring partner's share is to be in the partnership assets, including goodwill, is to be acquired by the continuing partner or partners, then the retiring partner is, in the absence of agreement, entitled, if necessary by order for sale, to receive his appropriate share of the assets. So then Mr. Justice Goff went on to hold that, as is D to E, the paragraph that starts between D and E. In my judgment, what he's entitled to is the value of his share at the date of his retirement, including, of course, the then goodwill, the ascertainment of which must, at all events, normally be a matter of inquiry, accounting, evaluation, not sale. Once that conclusion is reached, then sections 42 and 43 of the Partnership Act do not apply. Once that conclusion is reached, then sections 42 and 43 of the Partnership Act do apply, and whatever is due to the plaintiff, whether under section 42 or in general account, as a debt due to him from the continuing partner. So the judge rightly held that all of those principles applied. Because quite simply, before the technical dissolution, Susie had a partnership share, undoubtedly, which amounted to a quarter interest in all of the assets of the partnership. And she was entitled to that interest upon leaving. So if the other partners wanted to continue to use those assets representing her quarter.
When you say she was entitled to those assets on leaving, what's the basis for saying she's entitled to them?
Because immediately prior to her retirement, she was entitled to a 1/4 share in the entirety of the partnership, being her partnership share as defined by Lord Lindley.
So that's the net position as between partnership assets and partnership liabilities.
Yes. And her the simple fact of her retirement can't divest her of that 1/4 interest. There's nothing to suggest that a simple retirement, a simple
So she retains a property right in those assets?
I don't see that she can retain a property right. It does seem a little bit twilight.
The case you're facing is a very simple one, which is it was agreed that she should leave. That was mutually agreed. It was agreed that the others would carry on. That was mutually agreed. It was agreed that in those circumstances, the assets and liabilities would all accrue to the continuing partners, and I don't think that's disputed.
The judge doesn't quite put it in those terms in the judgment. He said at paragraph 226, line 3, that the continuing partners taking on the assets and liabilities.
Do you say that
Taking
It may be a matter of semantics, and it may well be that they are the ones who. It's difficult to say that they retain a property interest in it, because when one looks at the interest of a partner in in a partnership, it's not a beneficial interest in, for instance, land. It's recognised that they don't have those sorts of interests. They simply have
The
an
right,
interest
the
in
right
the
of a partner,
asset.
the right of a partner, the interest of a partner in partnership assets is to have them used to meet the partnership liabilities and to share in any surplus left over at the end. But so long as the partnership business is continuing, you can't enforce that right by sale because that's inconsistent with the business continuing.
Yes.
Obviously, if there's a general dissolution, you have an actual sale and you can have an actual surplus. What we're interested in is what is the right of an outgoing partner where there's not going to be an actual sale because it's agreed that the continuing partners will continue the business. And what is the nature of that right?
Well, it's a right, it seems, that Sir Bell and Boston identifies as simply a right to be paid out their partnership share, the value that they had immediately
At a valuation.
At a valuation, yes. Because there's...
Where does it come from? It doesn't come from the partnership deed expressly, does it?
It may be a consequence of what might otherwise have been the right had there been a general dissolution and winding up, almost by parity of reasoning. But I don't think any of the cases go so far as to suggest that's where it derives, because otherwise we're deriving something from the Partnership Act. And Lord Justice Longmore says, no, you can't imply something from statutory provisions that just don't apply.
Is there something in the point that if A leaves an A, B, C partnership, the decision to carry on, if they're going to do it, is a new agreement between B and C, to which A isn't a party? I think this may be similar to your parity with general dissolution point, that in the absence of agreement about any other terms, why should A be in a different position to that A would have been in if B and C had also, on that event, chosen not to continue in what technically is a new partnership between B and C?
Precisely, and that's the way that Lord Justice Rymer looks at it in Ham and Ham. He says, well, the reasonable man would be astonished if a month after, or a week after, the other partners who have claimed an accruer could, as between themselves, wind up the partnership and scoop the pool, keep the lot. And it may be then, as the judge speculated, it's an implied term.
Implied in what? Implied in the original partnership deed or implied in the ad hoc agreement to retire? Or?
Implied in the ad hoc agreement to retire, yes, because that's the agreement that must be being interpreted.
What is the term that's implied?
That the outgoing partner should be bought out at a valuation. That the outgoing partner's share
So
should
in a sense, entitled to the value of their share of the assets.
their share of the net assets and liabilities, as if on a general dissolution. That it seems is the way that Mr. Justice Goff
And how,
assesses it, and the textbooks.
but in this case, the judge has held that the entitlement is to a market valuation of a particular asset.
Because he said in the declaration that all the other assets and liabilities having been dealt with, and this being the only remaining outstanding asset.
Can you explain that? I mean, I saw that's what he said, but what does he mean by saying they've all been dealt with? This doesn't seem to be in dispute. But in what way have the other assets and liabilities been dealt with? Has the bank been paid off? I mean, what's happened?
Because it was the view that was taken, it was a fairly pragmatic view, I think, was that all the pros and contras should be offset against one another, and that be represented by the claimant's, Susie's, capital account. And so, given that that was a negative balance, which reflected given that that represented pluses and minuses, and necessarily must have included assets for which inevitably, therefore, Susie was getting a quarter share.
So, but that's things like farm machinery and so on.
Yes,
that-
everything. Yeah.
And no one sought to argue that the assets are different in value from the book values.
Sorry, so if I've understood it correctly, what you're saying is that the 40-odd thousand that she paid as the amount standing, negative amount standing on her capital account, has been treated by everybody as dealing with all the other assets and liabilities of the partnership, other than, that is her interest in all the other assets and liabilities, other than the Agricultural Holdings Act tenancy.
Yes, because it wasn't worth the candle
Well, that's a very sensible attitude, if I may say so.
to take.
What it
You-
means is that we're not considering here the sort of blue sky argument, which is what happens to the assets of the partnership.
Exactly.
Here the parties have agreed to limit the dispute
Yes.
to one asset,
Yes.
and so it wouldn't be right for us in those circumstances to allow a thought to go through our minds. Well, that's all very well. This former partner is just zeroing in on one,
Exactly.
as it were, a plum,
Exactly.
and ignoring all the duff. In fact, the parties have agreed to fight the battle on that ground in relation to that. And so whether or not it was a good deal for anybody to have written off the 45 and all the other assets and liabilities is not our problem.
No, exactly. And the point that Lady Falk made about book value is subsumed into that it just wasn't worth fighting the difference between its actual value and having a valuation on it and its book value, because we'd spend back here arguing.
Right.
But what it does mean is that your argument is in fact, although we're arguing about the value of the tenancy, your argument is in fact that what she was entitled to back in 2010 was a revaluation of everything, all the
Yes.
assets in strictness.
Yes,
It's just she's just not chosen to pursue that.
exactly, yes.
Yes, I see.
And that's certainly the way that the books represent the position and the cases, Sobel and Boston.
Well, you say the books represent the position. Do the books do any more than simply reflect what Sobel and Boston decides?
Well, they also reflect the law in Scotland, the Easton and Miller case, which says the same and relies on other case law in Scotland. So it's not as though it's a unique jurisdiction that Mr. Justice Goff has decided. It does seem to be a recognised principle. And indeed, it just follows, in my submission, the reasonable man if we go on to the implied term or implied contract point. My lord, did you see the Easton and Miller case, which is at page 64 of the bundle, and it's the relevant paragraphs are 24 and 33 at page. Page 72 of the authority bundle. By Lord Doherty said, paragraph 24, in my opinion, it's also correct that on the retirement of the partner, is at least a technical dissolution of the partnership, and he cites Hadley and Chief Justice Eichelbaum, Miller on partnership, and Lyndon Banks in the case of Jardine Francis and Maxwell. That's the Scottish case. She goes on to say, the partnership agreement provides that the partnership will continue notwithstanding the retirement of the partner, and makes provision for continuing partners to acquire the retiring partner's share at a valuation or in some other manner. In that sense, retirement from a partnership usually connotes continuation of the firm. See, I think I should say Lindley and Banks rather than Lindley. But if a partnership agreement does not provide that the retiring partner's entitlement is to be on retirement, the matter is governed by the general law. Under the general law, a retiring partner is entitled to obtain an equal share of the whole net assets of the partnership. Bennett and Wallace. And Shaw and Clark and Watson. When he says equal share, I presume that's in the context where each of the partners is entitled to an equal share rather than an unequal share.
So how does this work? That you're relying on this just simply being the general law, and the judge, in reliance on the textbooks, similarly relied on that. So where does the point of the implication of the term come in to your argument?
Well, I could take some adverse fire on this point because I haven't filed a respondent's notice, so I haven't said you can uphold the judge's decision for different or other reasons. But what the judge does say is it might be as a consequence of an implied term or implied contract. And simply, on the back of his saying that, I explored whether that would work. And that's the balance of my skeleton argument, really.
Do you want to explain, since that's what you've put in your skeleton, why it's necessary to give business efficacy to the retirement, or why it goes without saying? I mean, Mr. Peters said, and there is obvious truth in this, that sometimes having to revalue all the assets of a partnership such as a farming partnership might lead to a very large capital sum being payable to the estate or to an outgoing partner, which the partnership could not easily afford. So that's difficult to say, it goes without saying, isn't it?
Well, this is perhaps the point that's addressed by Lord Justice Rymer in the Ham and Ham case, because he goes on to look at what the reasonable man might consider would be fair or reasonable in the case. Can I go through the way that the argument runs?
Yes.
So the test for implying terms is either so obvious as going without saying, or necessary to give business efficacy. That's the M&S and BNP Paribas case. And Lord Neuberger said that the so obvious test is concerned not with the hypothetical answer of the actual parties, but the answer of notional reasonable people in the position of the parties at the time they contracted. And then M&S, I've cited paragraph 23, reference is made to the reasonable reader for the purposes of implication. So paragraph 57.3 of my skeleton cites from M&S the notion that a reader term will be implied if a reasonable reader of the contract knowing of its provisions and the surrounding circumstances would understand it to be implied as quite acceptable, provided that one, the reasonable reader is treated as reading the contract at the time it was made, and two, he would consider the term to be so obvious as to go without saying or to be necessary for business efficacy. And the difference between what the reasonable reader would understand and what the parties actually reasonably would agree appears to be a notional distinction without practical difference. And then in the context, not of implying terms, but of construing an agreement, namely the partnership agreement, in Ham, Lord Justice Rymer, and this is page 49 of the authorities part, paragraph 67.
It's actually page 49 of the core bundle as well, happily, because you're reading from your skeleton argument. So,
I am, yes.
yeah, well, it's there.
Oh, yes, yeah. I think I've cited most of the relevant paragraphs. One shouldn't leave the question of interpretation.
Yeah, shall we read that paragraph to
If you
ourselves?
would, yeah.
Yes.
So, my Lord, there are perhaps three key points out of that. That's line 4 to over the page. He'd be surprised, the reasonable man would be surprised if there was an accrual to the other partners. He would think it's intuitively unfair. Particularly so if a month or so later, the brothers decided that they were going to wind up the partnership and keep it for their own benefit. because of course jus accrescendi inter mercatores locum non habet, survivorship doesn't apply between merchants. And he then goes on to make the key point, which applies to our case, that it'd be odd if there were any special and different rules for family farming partnerships, which is obviously critical. So the starting point for implying terms, I start from the position of what about the no-fault retirement by death of a partner, because that's just not covered by the 1980 partnership deed. So what happens there? And it seems that there must be an implied term of an entitlement to the normal partner's share upon somebody dying and leaving the partnership by dying. So, Lord and Lady, you'll remember from the partnership deed clause 14.3, back in the first supplemental bundle, page 7 to 8, that there are 4 types of technical dissolution. The first 3, Romans 1, 2 and 3, are at-fault cases, and the 4th is a no-fault case of death, retirement by death, deemed retirement by death. And in respect of the at-fault cases, clause 14.3 then goes on to prescribe that outgoing partner's entitlement, and it's a limited entitlement. But clause 14.3 is expressly disapplied from a retirement by death, the no-fault retirement. Now, if that's so, what's the entitlement of that outgoing partner's estate? Because the deed is entirely silent on the matter. And plainly, a deceased partner, a no-fault partner, was not intended to have the same entitlement as an at-fault partner, and it'd be highly surprising if they were intended to be worse off than an at-fault partner. And so the only realistic possibility is that the entitlement of a no-fault partner is the entitlement to their partnership share. And I don't say that in isolation. Partnership share as understood by Lord Lindley. I say that with the backing of the defendants themselves, because their own pleading at second supplemental bundle, paragraph, page 112. And paragraph 11, Roman 1. The exclusion of the death of a partner from clause 14.3 indicates that a deceased partner has the same rights and liabilities as on a dissolution, which can only mean a general dissolution and winding up, rather than being restricted to payment of his partnership share defined in that clause. So that's the defendant's own case. So where does that come from? It must be the basis of an implied term, but clause 14.3 not applying to a deceased partner, there must be an implied term that the deceased partner is entitled as on a general winding up.
As to this, we've got your submission fully in writing, haven't
We do,
we?
yes.
Paragraph 61.
Can I ask one question on that? You're in relation to death, you must be saying there's an implied term, and there was in 1980 an implied term when the
Yes.
partnership agreement was entered into. Our situation, I think you said earlier,
Yes, I did.
relates to a different agreement.
It does, because it's, but it's by parity of reasoning. We're in exactly the same boat. We must be, because the same reasoning would apply. Lord Justice Reimer's reasoning that we see in the Ham and Ham case that we just read through. I accept fully that it's that must be an implied term into the 1980 deed relating to entitlement on death, and ours is equally not covered by the 1980 partnership deed. It might be that it could be simply implied into the 1980 partnership deed, but on the other hand, one could imply it as an alternative
It's
into
quite
this
difficult.
agreement.
It is quite difficult when retirement, other than by death or a fault-based one, is just not contemplated.
Exactly.
I suppose you would say the only alternative is that on death, we know, because the partnership deed says so in clause 3 and again in clause 14.2, that death does not work a general dissolution. So that the partnership is intended to carry on if one of the partners dies. The only alternative to the surviving partners accounting to the outgoing estate is that they get the assets without payment at all. There's no provision for any payment from the ongoing partners.
But that's where I make the distinction that it would seem inherently unfair that a no-fault exit by death is worse off than an at-fault exit, which is provided for by clause 14.3.
Yes.
Which is why I say a no-fault exit by death surely must be better off than an at-fault exit by eviction under clause 14.2. Roman
So that's the
43.
first step in your argument, and then you say the same must apply to retirement,
Yes,
unless something else is agreed.
exactly. Yeah.
And I think the argument against you is if you want to be paid on a retirement, you have to actually agree it. If it's not agreed, it's not agreed. That's what Mr. Peters said.
In which case we simply come back to the position immediate, as Lord Justice Jackson said, immediately before the retirement,
There was an asset.
there was an asset, there was an entitlement to a quarter share.
So your main case is that you don't need an implied term.
No, I don't.
Is that you have an entitlement
Absolutely.
to the value of,
Yes.
but your second string relying on the rather gnomic sentence in commentary on this Justice Goff by the judge is that a term could be implied if you needed it.
If that were the basis on which Sobel had been decided, yes.
Yes, but I mean, I have asked Mr. Peters why it should be you that has to imply the term rather than him.
Well, exactly, yes. if
If it's your assets,
I'm sorry,
if it's your assets and liabilities,
yes. It's my entitlement to a quarter share. It's for him to say why it's divested from me by leaving the partnership, by a simple resignation without any agreement as to how I should lose how my client should lose her quarter share in the partnership.
Does it come down to this? If I've understood it correctly, your case without an implied term goes like this. Before, when I was a partner, I had a partnership share. We know what that is. It's a right to have the partnership assets used to meet the partnership liabilities and a quarter equal interest in any surplus left over. When I leave by death or by retirement, they're still my assets unless I've agreed that someone else can have them.
Yes.
So by retiring, I do agree that I mean, if I didn't agree that you could carry on in business, I'd be entitled to have my share quantified and paid out by a general dissolution, by a winding up. By agreeing to walk away and retire and leave you carrying on the business, I've agreed that I'm not going to press for a general winding up, but I haven't given up my entitlement to the assets, save in the sense that I'm letting you use them, but it must be on terms that I get paid what they're worth.
Exactly.
Is that?
Yes. That's the start. That's the non-implied term.
So it is a sort of dissolution light in the sense that instead of having a general dissolution, I accept that because I'm resigning or retiring rather than pulling the whole edifice down, I'm not going to have the affairs wound up, but I'm going to have a sort of notional winding up so I can be paid out what I would have got. Is that it?
That's exactly it, and that's the way Lindley and Banks phrases it.
and if that places a business like this farming partnership would place them in an intolerable difficulty, then you can't leave without agreement.
Or alternatively, go to court for a winding up of the partnership.
But you wouldn't get a winding up of the partnership just because you wanted to. I mean, It's quite.
No.
I know the judge left it open, but it's not a partnership at will. It's not one you can just bring to an end whenever you want to, is it?
No, and it may be that it's almost quite literally a Hotel California position.
Yeah.
You can check out, but you can never leave.
Yes. So if father had been well advised,
Which is clause 14.2,
Yep.
subclause 4 deals with the checkout. But
Yes.
otherwise, you can't leave.
well, except by agreement. But if father had been well advised, he could have said to you, you can't just walk away from it. You can only retire with our consent, and we're only going to consent if we agree with financial terms. But he didn't do that. He said, yeah. So the solution, because there is a problem that Mr. Peters highlighted, that with a farming partnership like this, it may be asset rich but cash poor, and that somebody being entitled to a payment when they leave may cause real problems.
Of course.
But the solution is either to put something in your deed in the first place, or to say, well, you can't walk away unless we agree terms.
And father says you can walk away.
While you're on your feet, in what sort of amount is this claim valued by your client?
I think we've yet to find the have the valuation of the HHJ tenancy, and it very much depends upon the basis of the valuation. There's a spat as to how it should be valued still, which has to go back to the trial judge. That you may have seen those that's in his directions at the end of the last trial.
Yes. So what?
Can I take
Yes.
brief instruction? It's somewhere between 180,000 and double that figure
Your claim, not the total value.
for the quarter share. Yes.
And am I right in thinking there's no dispute, there's no appeal against the judge's decision? That takes effect under section 42 to give you 5% interest back from the date of
From 2010, yes.
2010.
Yes.
And that's not been appealed.
That was conceded, I think, at trial by Mr. Peters on the basis that, assuming that we went on the main point. I think I've flagged that in the skeleton of relevant paragraph.
Yes.
I'm conscious that I've got a fair bit left of the skeleton, but I'm conscious also that you've read it and we've
Yes.
hit
Well,
the
I know.
mark.
I mean, you've been very helpfully tracking your skeleton argument, and so we do have your arguments on this, which is, after all, a fallback position,
Yes.
fully set out in writing, and we want to give, obviously, Mr. Peters an opportunity to reply.
Yes.
So,
Is there anything
can you manage to complete within the next 5 minutes?
Well, I'll try.
Thank you.
You have the voluntary retirement parity reasoning
Yes.
already at paragraph 61. My learned friend says it's an implied term would be inconsistent with what was agreed, but of course there was nothing agreed, so there'd be no inconsistency problem there. As for Bottrell and Harling, given the answers to that at paragraph 63, I don't think that is on point, because in that case, and I should correct the last one on core bundle page 52, I've said appellant's alternative argument is actually the respondent's notice argument. Justice Longmore considered an argument that on a technical dissolution with no express agreement about repayment of capital contributions to the retiring partner, we'd be entitled to this capital contribution as a matter of legal implication pursuant to section 39 of the Partnership Act 1890. And Lord Justice Longmore said that would be a difficult argument. Of course, that's because Lord Justice Longmore rightly observed in paragraph 23, section 39 only applies on a general dissolution with winding up. It doesn't apply on a technical dissolution, just as Justice Lewison had said in Ham, and indeed our judge had said in this case. And so, perhaps inevitably, Lord Justice Longmore observed that implying a term based on section 39 in a technical dissolution to which section 39 just doesn't apply, was bound to have some difficulty. It's perhaps more telling that Sobel and Boston wasn't relied on. As a matter of an express agreement being construed instead. My lords, my lady, I don't think there's anything else. It may be that I need to deal with the basis of valuation. Which is Appeal Issue 1.3 and 1.5, down at the bottom of page 53 of the core bundle. I flagged there again that Lewis and in Ham distinguished between capital assets and the partner share. And the partner share is defined as his proportion of the partnership assets after they've all been realised and converted into money, and all the debts and liabilities have been paid and discharged. That's Lord Lindley's definition, cited by Lord Justice Lewison at paragraph 20 of page 38 of the authorities bundle. If that is the definition for a share, his proportion of assets after they've been realised and converted into money, necessarily that must be market value. So one doesn't realise other than as market value. And then there is, I do a little bit of sweep up and deal with the definition of partnership share in section clause 14.3, which is quite clearly only for the purposes of clause 14.3. It's not a general definition that's been imported to every other meaning of partnership share in this case. And then finally, clause 5 and the partnership accounts, quite simply, they don't change anything. Fraction is quite clearly a quarter. That comes from the 1987 partnership deed and mother's retirement, by which the children ended up each with a quarter share, and father had a quarter share. And then the inquiry and interest simply followed as a consequence of Sobel and Boston. Or is there anything else I can help you with?
Thank you. Yes, Mr. Peters.
Well, also a number of issues arising from that. The first is whether there was an ad hoc agreement to retire. I think Mr. Walker at one point was saying there wasn't, but it's clear that in my submission there was, and that's clear from paragraphs 223, 224 and 226 of the judge's 2022 judgment. And indeed there couldn't have been a retirement other than by an ad hoc agreement, because as we have seen, the partnership agreement did not allow for retirement in this circumstance. And we've seen that the law is clear that retirement has to be by agreement. What he really meant in my submission was effectively an admission on his part that there wasn't any ad hoc agreement of a term that the continuing partners would pay his client anything. Then one moves on to the related questions of effectively what is a retirement by agreement? What, if anything, is left, as it were, as an entitlement? So Mr. Walker and or Justice Nugee were referring to. How does that fit in with this court's decisions in Re White, Drake and Harvey, and Ham? And where does that leave Sobel and Boston? And in my submission, one starts with what is the nature of a retirement in the terms that we started out looking at this morning, which is, one goes back to Lord Lindley's 5th edition at page 247 of the authorities bundle, and then what he says of the right to retire at page 248. What is a retirement in terms of its essence? It's surrendering the share and interest of the retiring partner in the firm to his co-partners. That's what he's doing. He's surrendering his share and interest to them. And then you ask, well, what terms is that surrender on? Well, it's on whatever terms he and they may agree. So that's whatever express or implied terms But that's of the essence of a retirement. He's surrendered his share and interest. So to the extent Mr. Walker was suggesting that after the retirement by agreement, which was common ground at trial and held in the judgment, his client retained any share or interest in the partnership, that's not correct, because that's of the essence of what was agreed. She had surrendered both the assets and the liability for the liabilities. And that's very much the same as what was said in Gray and Smith, which I referred the court to earlier at page 148. Mr. Justice Kekowicz, of the essence of someone retiring from the partnership. What are they doing? They're making over all his interest in the partnership and in the partnership assets. And in return, they're handing over the liabilities and being indemnified against the ongoing liabilities. So once the retirement by agreement had occurred, and it's common ground and held by the judge that that is what everyone had agreed, the claimant's interest in the partnership had gone. So the only question then is there any term of that retirement agreement that she should be paid anything by the continuing partners? And it's not disputed that the claimant didn't ask for or obtain any express term that she'd be paid anything. So the question then is there some basis for implying a term that she should be paid something, and if so, what? Or is there some amorphous principle of, quotes, the general law which applies, and if so, what is that general law? How do you get to that? And this in my submission, is very much interweaved with the suggestion that this question can be divorced or distinguished from the question in White, Drake and Harvey, Ham and Ham. In my submission, it can't, because if you look at what the question in those cases was, it was, what is the retiring partner or the deceased estate to be paid? And in particular, how do you value it? On what valuation basis do you do that on? And this court has said repeatedly in those three cases, you can't approach that with any default assumptions or any default rules as to what the relevant amount, the relevant basis of valuation and therefore amount should be, because parties have autonomy of contract and the circumstances of partnerships vary enormously, and the circumstances in which the retirement or death takes place vary enormously. So look at what has been agreed. My learned friend says, well, that's distinguishable from this case where you're asking the prior question as to what is the retiring partner's or the deceased partner's estate's entitlement, as he puts it. But as I've just outlined, in terms of entitlement, by its very nature, by the agreed retirement, she has given up her share, she's surrendered her share in the assets and the liabilities. The real question is, in terms of entitlement, is she entitled to effectively a term, an agreement that she be paid something? And of course, as soon as you ask that question, that inevitably is impossible to divorce from the question of paid what and assessed on what basis. So if you're saying there is no, as this court has said 3 times, if you're saying that there's no presumption or default approach by which you can say, yes, it's right to assume as the default or right to assume as the presumption that there would be full value or not full value, how can you possibly divorce that from the question of whether they have any entitlement? Because that is impossible to divorce from the question of entitlement to what? Entitlement to be paid what? So in my submission, one can't have any default rule or assumption, however you dressed it up legally, that someone who retires by agreement, or someone who retires by agreement but doesn't have any express term that we paid something, you can't have as your default rule that they will be paid at the full net value of their assets prior to the retirement, because that same presumption, if that was in place in that scenario, would be equally in place in Ham and Ham, White and White, Drake and Harvey, that the presumption wouldn't go away. That would always be your starting presumption. So what then displaces it? That's not the approach this court has taken. The approach this court has taken is to say, no starting presumptions or defaults. Look at what people have agreed. So if people surrender their interest in a partnership by agreement, they've given up their share of the assets and the liabilities. The only question is, have they agreed to be paid something? If so, what have they agreed? What have they agreed they should be paid? What basis of valuation? In respect of what? And if they haven't agreed anything, there is no room, consistently with those 3 Court of Appeal cases, to say there's a default assumption or default rule. What you have to do is look at the particular circumstances of the particular retirement and apply to the agreement the well-known test in M&S, and see whether in the circumstances of that particular agreement, for purposes of business efficacy, or so obvious as to go without saying, it would be right in a particular circumstance to imply a provision that the retiring partner be paid something, and if so, what, and assessed on what basis. And obviously the test in M&S is extremely well known. I'm not going to take you back through that, but just one reminder of one paragraph in that, not in relation to the test itself, but the reason why the test is there, which is in paragraph, I don't think I need to ask you to turn to it, but it's paragraph 29 of the M&S judgments, and it's on page 92 of the authorities bundle, quoting Lord Bingham in the Phillips case. And he stated there, it's because the implication of terms is so potentially intrusive that the law imposes strict constraints on the exercise of this extraordinary power. And in the context of a retirement from a partnership, the application of that is very obvious, because if people are retiring from a partnership in all sorts of different factual circumstances, if you have a default rule that a retiring partner will be entitled to the full revaluation of all of the assets and liabilities, unless there was some express agreement to the contrary, the court is effectively inserting there a very potentially draconian term vis-à-vis the continuing partners. And that's something where, if there is to be such a term, it's something which the parties should expressly agree. Otherwise, the position should be as clearly discussed in the 3 Court of Appeal cases. And as it were, further emphasising the fact that the question in this case is really no different in principle from the question asked in those cases. If one looks at the way that Lord Justice Briggs put it in Ham and Ham, the Ham and Ham is behind tab 4. Paragraph 5, Lord Justice Lewison, who gave the first judgment, had noted, before they went on to construe the agreement in that case, that in particular there are no presumptions or default rules which point towards one basis of valuation of an outgoing partner's share rather than another, re White, Drake and Harvey. Lord Justice Briggs agreeing with that at paragraph 41. Gratefully adopting Lord Justice Lewison's summary of the facts and indeed of the relevant law. So over the page, the end of that paragraph, I agree the answer to the conundrum which this case presents is entirely to be found in the true interpretation of the partnership deed. In other words, what has been agreed, read in the context of the partnership deed as a whole, with due regard being paid to admissible background facts. So in other words, looking at what has been agreed and interpreting it, with no presumption being applied one way or the other on the question whether any payment is to be made for or in respect of the unrealised profit or gain attributable to any increase in the value of partnership property beyond the amount recorded in the partnership accounts. Essentially, that's really what's in issue in this case, whether there should be a payment made in respect of a piece of property which the partnership had acquired as a result of its conduct from 1994 onwards, and which was an unrealised capital gain, in which when the claimant retired by agreement, there was no term of that agreement that she would receive any payment in respect of unrealised capital assets of that kind. And the way Lord Justice Briggs puts it there makes it very plain in my submission that there can be no default assumption or presumption that the retiring partner in that circumstance is entitled to a payment in respect of an unrealised capital asset. What you have to see is what they expressly agreed, and if they didn't make any express agreement about that, whether alternatively there might be any basis in the particular facts for implying such an agreement. And in relation to the approach which the judge took, in my submission, he plainly didn't take that approach. I won't take you through the paragraphs, but if one looks at, I'll just give the numbers, effectively, paragraph 2, 3, 4, he started as asking the question as what is a matter of general law the retiring partner would be entitled to on retirement. So that's the question that the judge thought he was asking himself. And then he thought the answer to that was fairly plain. He sets out what the position would have been on a dissolution, and then says at 240, having cited the paragraphs of Lindley and Banks and Blackett-Ord, which rely on Sobel and Boston, then at 240 says the matter is clearly dealt with by the decision in Sobel and Boston, cited by both textbooks in support of the passages that I've cited. And that's the basis on which he concluded that the claimant in this case was entitled to a payment. So he thought he was applying a principle of general law based on Sobel and Boston. But as I said this morning, if one looks at Sobel and Boston, there are good reasons for seeing why on the facts of that particular case, it might have been entirely justifiable for Mr. Justice Goff to have said that in that case, which where the partnership appears to have been a partnership at will, the outgoing partner was entitled to the quarter share, and the only question was essentially whether they were entitled for a dissolution and sale or to be paid out in respect of that share. But it does not follow that that is then a general principle of law that you can apply to every partnership and every retirement by agreement from a partnership. And that is particularly the case because, of course, Sobel and Boston was decided long before White, Drake and Harvey, and Ham and Han. And if one looks at the passage in Sobel, which was being referred to in this regard, Sobel's in the authorities bundle behind tab 2. On page 18 of the authorities bundle, so page 1591, citing that paragraph from the 13th edition, when a partner retires, the firm is thereby dissolved so far as concerns that partner, and if whilst making provision for such retirement, either originally, i.e. an agreement in the partnership agreement, or by subsequent variation, the partnership agreement is silent as to how the retiring partner's share in the partnership assets is to be acquired by the continuing partner or partners, then the retiring partner is, in the absence of agreement, entitled, if necessary, by an order for sale, to receive his appropriate share of the assets. But tied up in that are, first of all, an assumption that if an agreement is silent with regard to something, you can somehow impose a default rule. But also in relation to appropriate share of assets, and as Mr. Justice Goff put it further down, just above point E, in my judgment, what he's entitled to is the value of his share at the date of his retirement. If one steps away from a partnership at will, well, how do you value his share? You're straight back into what this court was discussing in White, Drake and Harvey, Ham and Ham.
Yes.
So, in my submission, to the extent that anyone is suggesting that Sobel was laying down a general rule, A, I would suggest it wasn't. B, it cannot stand with those subsequent Court of Appeal authorities. And in relation to the suggestion that the textbooks effectively rely on that in relation to the two paragraphs that the judge referred to in the judgment and my learned friend relies upon, the thing about textbooks is that obviously the person who's updating them, that first of all, doesn't necessarily have the luxury to sit pondering about every point. What they tend to do by way of updating is to put the relevant cases in at the point where they appear most obvious. So in relation to this court's three decisions in White, Drake and Harvey, Ham and Ham, those are all in the positions, the relevant points about basis of valuation, etc. But I would suggest that if the editors of the two textbooks sat down to think about how those cases sit vis-a-vis Sobel and Boston and looked at Sobel and Boston, it then becomes obvious that one can't apply Sobel and Boston as a default rule of law of some kind applicable to all cases.
Yes.
In relation to my Lady Justice Falk's question about if you have a partnership between A, B and C, why should A be, as it were, in a different position if there's a retirement as opposed to a dissolution of the firm? The point I would say in relation to that is that retirement is a very different thing from dissolution, and it occurs in different circumstances. So depending upon the nature of the partnership agreement, what's going on in the partnership at the relevant time, dissolution is not always available as an alternative to retirement. So in this case, the claimant did not claim at this point she was entitled to dissolution, didn't purport to seek it. What she sought was a retirement by agreement. And what one has to look at is where there has been a retirement by agreement, what the parties actually agreed on what they did, rather than what would have been the outcome if they had left the partnership in an entirely different way by seeking whether it's a dissolution that in other circumstances might have been available under the terms of the partnership or agreement, or a dissolution by applying to the court if the relevant grounds are available. But if what the parties have actually done is agreed to retire by agreement, then that's the agreement that they're fixed with.
Yes. Right.
I just want to mention, I don't want to trespass unduly on your time, but there was the question of the £42,000 and how that was dealt with.
45,800.
45,800, sorry. The position was, so far as the defendants was concerned, that they were always clear that that was a book value figure. They claimed that the claimant was obliged to pay it. She denied that. And eventually it was admitted that the claimant would pay that figure, and that was indeed paid. But at no point was it in any way accepted by the defendants.
What year was it paid?
Which year? It was 2021, I think. I'll just check.
Thank you.
Yes. So there was no suggestion that was anything other than book value.
But you don't suggest any more than Mr. Walker that if the judge's decision stands, that it applies to anything other than a tenancy. That's the only asset in issue.
Yes. What I'd say was it highlights, as it were, the mismatch between the implied term which the judge inserted and what had been actually done with the partnership assets and liabilities. And in relation to my Lord Justice Nugee's analysis, as it were, of effectively the suggestion that is it possible that what has happened is that a person has retired but somehow retained an agreement to be paid. I think I addressed that in my the beginning of my reply. I don't know if there's anything else I can
No, thank
assist
you,
the
Mr.
court
Eaves.
with.
Very well. Thank you very much for your arguments. We will think about this and let you have our judgments in due course. You'll receive them in draft, limited to the circulation agreed with our clerks. We'd be very grateful for any corrections that may need to be made, and for a draft order reflecting our decision. If there are any matters that you can't agree between yourselves, please give us short submissions in writing, and we won't need to trouble you to attend for the hand down of the judgment in formal terms. Thank you very much indeed.